And we'll now go to the final matter for argument today, which is World Fresh Market versus Lenore Mercedes PALERMO, number 12 of 2020.
With court's permission, I'm leaving.
Yes, you all may be excused. Thanks for attending. Okay. Attorney Lawrence, are you ready? And,
I can't hear her.
okay.
Sorry, I'm the appellant this time for once.
Okay. Okay, Attorney R.C., are you going to be doing the argument?
Yes, Chief Justice Hodge, thank you. Can you hear me all right?
Yeah, we can hear you fine. Do you wish to reserve any time?
5 minutes, please, Chief.
Okay, then we can proceed.
Thank you. I'm Dwyer Arce of QTech Rock, representing appellant World Fresh Market, doing business as Pueblo. I'd like to start out by apologizing for my tardiness joining this call. I was left in the waiting room because apparently I am still listed as a law clerk and was asked to watch the live feed instead. So apologies that I was a little bit late getting on the call. World Fresh, sorry, Chief.
I said sorry for that.
Oh, no problem at all. World Fresh Market prays the court vacate the judgment of the Superior Court and remand for a new trial due to 4 separate errors, each of which standing alone warrants a new trial. The first of which is that the Superior Court erred in excluding evidence from trial of the negligence of a joint tortfeasor that the plaintiff herself alleged was negligent. The Superior Court erred in failing to apply 5 BIC section 427 and permit World Fresh Market to offer evidence of compensation the plaintiff had received for her injury. Superior Court erred in refusing to instruct the jury on plaintiff's assumption of risk despite finding evidence supporting that instruction, and the Superior Court's error in admitting expert testimony on lost earning capacity that had no evidentiary basis. With all that said, this case has been briefed to death. As I'm sure the justices and their clerks know, there have been thousands of words beyond what is typically allowed in this case. And I know that, at least on our end, we appreciate that indulgence from the court. And I will continue with my argument, but I would waive the remainder of my 3 minutes of question-free argument time and invite any of the justices to jump in at any time that they feel is appropriate.
Oh.
It was nearly a decade ago that this court decided Banks and began the process of creating an orderly and cohesive body of common law made by and for Virgin Islanders. Virgin Islands courts are now required to conduct a searching and thoughtful analysis whenever presented with the question of common law not addressed by the Virgin Islands Code. This inquiry, as every Virgin Islands judge and attorney knows by now, requires the court to first look at what Virgin Islands courts have done before, what other courts in the country do now, and then to determine what the soundest rule for the Virgin Islands is.
But do we have the authority to create common law where there's a statute?
Chief Justice Hodge, there is, and to the extent that the statute applies and addresses the issue, this court would not have the authority to, for instance, rewrite or ignore that statute. In this instance, there is no provision of the Virgin Islands Code which addresses this instance and directs what must be done when a co-defendant is dismissed by a pretrial settlement. We have, of course, 5 BIC.
The statute does provide for apportionment among defendants, right? Doesn't that indicate that is what the legislature intended? And would it be proper for this court to somehow create a common law that would do away with that requirement? That it be apportionment only among defendants?
Yes, Chief Justice. Well, the answer, I guess, to both parts of that is yes, in that the 1451 does not exclusive to co-defendants. There is no language in 1451 or anywhere else in the Virgin Islands Code which says liability may only be apportioned to co-defendants and may not be apportioned to dismissed co-defendants. So, for example, we have
But it addressed the issue of apportionment, and it limited to defendants. It didn't, like other statutes, do away with joint and several liability. It kept that in. So why should we now say, well, the legislature meant to allow third parties to be apportioned in a case in which they're not involved in?
Well, Chief Justice, the statute addresses one circumstance that's not what is occurring in this case. So in a situation where there are two co-defendants, 1451D requires an apportionment between those co-defendants. But where there is only one defendant and a non-party joint tortfeasor, 1451D simply doesn't tell us what the answer is. And in the absence of a statute dictating the results, this court has always turned to banks, and the banks analysis.
Attorney, hold on one cotton picking minute there, Attorney, because you are going fast, and I have a whole lot of problems with what you are talking about. We have a statute here that talks about comparative negligence. And the comparative negligence that we are talking about, basically, as I understand it, is whenever recovery is allowed against more than one defendants. Now, if these people, PDCM Associates, who was the owner of the building, if they want to go to mediation, as your client also went to mediation, all three parties went to mediation, and if they want to make a conscious decision, and that decision has nothing to do with negligence on their part, because two things. One, people go and they settle a case because they decided that, well, I might come. It's an economic decision. They made an economic decision. And remember, no judge or jury have said that PDCM Associate is negligent. That was never made a determination. And and they don't admit any negligence on their part. So that, and they were dismissed out of the lawsuit because they settled. So what you want to do is to force them back into the lawsuit to defend so that we can have an apportionment. If you were going to do that, then why could you not have filed under our rules, under Virgin Island rules of civil procedure? Why didn't you go and file a cross-claim under Rule 13 of the Virgin Island rules of civil procedure? Or if you wanted to, why couldn't you not have gone to Rule 14 of the Virgin Island rules of civil procedure and file under third-party practice and file a lawsuit against those people, which is PDCM Associates, if you think that they were negligent as well and there should be an apportionment? But under comparative negligence here in the Virgin Islands, it's explicit, it is succinct, and it is artfully crafted that is said that we are talking about defendants, and to dismiss a defendant out because the defendant settled, making an economic decision. I don't want to go to trial. I don't want to pay attorney fees. I don't want to bring in experts and the time consuming and whatnot. If they made that decision, that is an economic decision, has absolutely nothing to do with liability. So why should they be punished? Why should they be punished because it's settled?
Justice Swan, it's a great question. And we are not asking anyone to be punished because they settled. And we are not trying to bring the landlord, PDCM, back into the case. The only thing.
But didn't you ask for some collateral source? The collateral source, when you were saying that, and much ado was made about this, that whatever was paid out by PDCM ought to be deducted from the judgment against Pueblo. As a matter of fact, when I read the amicus curiae brief, the amicus curiae brief is talking about that. The amicus curiae want us to get that money that that was paid by PDCM in a settlement through mediation and deduct that from the judge, the $600,000 judgment against your client.
And Justice Swan, perhaps that's what the amicus is asking for. That's not what World Fresh Market is asking for. We are not asking for, they're two separate issues that are being—
as part of the record here, that's what the association, the amicus curiae brief is talking about. I'm just saying, and they represent the insurance companies.
Sure.
Attorney, you're saying the same thing, and you're saying that the plaintiff gets a double recovery. So basically you're asking that it comes from the judgment.
Will the judgment be reduced to that extent?
No, Chief Justice, Justice Swan, what we are asking for is to give the information to the jury so the jury can make that determination. These are two separate issues that are being presented.
Why should the jury have that? Because the only people is going to benefit is any judgment against your client. But like I said, no, the juries, they decide liability and damages and negligence and all this sort of thing. But if this has the settlement between the plaintiff and PDCM, you know, if they want to settle with economic consideration, because remember, there has been no adjudication of liability against BDCM. As a matter of fact, attorney, you got to be very careful with this case, because remember, this accident occurred in Pueblo, in the supermarket, where Pueblo has exclusive control over that area. Pueblo employees traverse that area. Public employees are working there. Is the premises leased by Pueblo, in which Pueblo determine what's what and operating their business? That has absolutely nothing to do with the operation of BDCM, except that they are landlord and you're leasing from them.
That's true, Justice Swan, except for the fact that the plaintiff sued the landlord as well as Pueblo, alleging they were both negligent. So the only thing that World Fresh Market was trying to do at trial is to offer evidence supporting the plaintiff's own allegations, which were excluded from trial based on a finding that they were not properly pled, even though they appear.
All right. Attorney, the whole idea is that in the amended complaint brought in PDCM Associates, right? All right. But once they came in, and if you believe, if your client, if Pueblo believe that somehow PDCM should be a part of this or should foot part of the bill, then why wasn't a cross-claim under Rule 13 of our rules? Why didn't you file a cross-claim under Virgin Island under the Virgin Island Rules of Civil Procedure that allows you to cross-claim against them?
Well, the reason
now, after the lawsuit, I don't know if the third party practice won't allow you to do that, but certainly from the time that amended complaint was filed, it should have conjured in somebody's mind that, well, you know, we want to make sure that PDCM pays some of this, so cross-claim. So there's a vehicle. But the vehicle is not to disturb that settlement, which is encouraged by the law, the settlement between the parties in which no liability is ever admitted.
Attorney R.C., you wanted to have introduced into evidence the settlement. Is that correct?
Yes, sir.
How does Rule 408 of the Rules of Evidence apply to that?
Well, Rule 408 prevents a party from using evidence from settlement negotiations in support of their substantive positions. We are not trying to offer evidence of a settlement agreement that we are a party to, that World Fresh Market is a party to, or try to negotiate. Simply trying to offer evidence that funds were paid to the plaintiff for her damages as permitted by Section 427. And to the extent that there's any other—
How is that not violative of 408? It says, you know, prohibited uses. Evidence of the following is not admissible on behalf of any party to prove or disprove the validity or the amount of a disputed claim, or to impeach, etc. And it speaks specifically of a settlement furnishing, offering, accepting, promising to accept valuable consideration, and compromising or attempting to compromise the claim. Why, if this is admitted, it wouldn't be in violation of this particular rule?
Well, it wouldn't be in violation of Rule 408 because it's not being offered for the purpose of saying.
First of all, is among defendants. And apportionment by statute relates only to the defendant's liability among each other. When it comes to the liability of the defendants to the plaintiff, it's joint and several. We've been trying to explain this and make that clear throughout our briefing. So absolutely not. There was never any adjudication of liability. People compromised their claims for many, many different reasons. There's a whole list of reasons why people end up compromising their claims and deciding to settle.
Okay, you agree that Pueblo can seek contribution, can bring an action now against the landlord. I don't remember all the initials, so I'm just the landlord. Couldn't they do that now? At least in Deloitte didn't agree that the statute of limitations doesn't begin to run until the judgment is entered.
But we told them that. So what they're trying to do is have Ms. Palermo.
If they go against the landlord and get a judgment against the landlord for what they paid you, is the landlord being punished twice?
Listen, when it comes to whether or not or what remedies Pueblo may or may not have against PDCM as a separate action, once again, has nothing to do with the plaintiff. And I understand.
But this is why they're saying that because of this unfairness, that the court should use its common law, use its jurisdiction, adopt the apportionment amongst non-parties, tortfeasors, to remedy this unfairness, that you inherently recovered more, double for your injuries, or at least in excess for the same injuries. So why should we not find that this only deals with parties, and that, as other jurisdictions have done, find that the court can adopt the common law, which allows for apportionment among non-parties?
Actually, no jurisdictions have found that. We were interpreting, and we tried to point that out in our briefing. You're interpreting a statute. I know that the appellants have argued that this court can now craft a common law doctrine, but this court can't. They're attempting to create a common law issue because PDCM squarely does not fit in the definition of 14 BIC for apportionment. And the legislature has mandated that apportionment can only occur among defendants. So the Superior Court was not wrong. There was no error here. And remember, the standard is abuse of discretion. Did the Superior Court abuse its discretion in disallowing evidence related to PDCM's liability, where they were not an active participant in trial, 1, and 2, were not a defendant because they were dismissed with prejudice from the litigation? So this whole common law, going off into this common law issue, is a creation by the appellants because they're trying to create this side pathway, because our legislature has already been clear that it can only happen among defendants. And that being said, even if the Superior Court was wrong, the appellants still have not shown how they were ever going to supply evidence or prove any of this when they didn't preserve any of these issues in their joint final pretrial order.
Attorney, I have a burning question, and the question is simply this. From the time that amended complaint was filed, bringing in PDCM, and looking at Virgin Islands rule, if in fact that Pueblo did not bring in PDCM, That's not your fault.
But
Because the rule under Rule 13 is their big and broad across claim. And if the statute of limitation have run on their third party practice claim, that's not your fault.
This is what we've been
Why
trying
must you?
they're trying to make this. Remember, what they're trying is to have Miss Palermo, who has had a jury say that she's owed $600,000 because of Pueblo's negligence. They want her, who's waited 11, now going on 12 years for a trial. They want her to go back to a no trial again.
Attorney, let me make this last point. Even if the landlord was responsible for repairing the roof under the lease with Pueblo, and I think that you said no, they were not, but anyway, even if that, the repairing of the roof, how does Pueblo get around the fact that they have exclusive control of the area? Water is coming through the roof, it goes on the cooler, it comes on the floor, they have employees there punching prices on items. And this thing about whether or not contributory negligence or whatever, that's nonsense. When people are shopping, when you have a business and you invite me in as a business invitee, when I come in to shop, I'm going in there to look at the prices. I'm not going to be looking on the floor unless you have an object there. Now, it was incumbent upon Pueblo under these circumstances that once the water came in and was seeping under the shelves, coming out into the aisles where they have invited customers in to spend their money, then it's their fault. Because they had an opportunity to prevent all of this accident if they had mopped the floor, if they were diligent, if they were not allowing the water to hit the cooler and come down. And this has nothing to do with the roof. It has to do with what's on the floor.
And Your Honor, that's what the trial ended up being about. And that Pueblo brought 0 liability witnesses at trial. 0. They brought no one to go and present.
Well, they did bring the doctor.
Well, the doctor was a damages witness.
But nobody on damages as such, or nobody on, you're right, nobody on liability.
Nobody on liability. And so now
they had one witness.
Now they're asking for a do-over, and they're creating this completely new case that didn't exist. There is a record here that spans. That's one of the reasons why this was one of the hardest cases for me to brief, because my starting draft was 20,000 words, because we actually had a record. And so it was hard to now be faced with I'm trying to be an appellate briefing and an appellate case that just didn't reflect what occurred below. And the whole idea of this Banks analysis, none of this Banks analysis that they're claiming was supposed to be done was ever done by them before the Superior Court. All of this pro tanto, proportionate share. Listen to me. I've been briefing for a long time. This stuff was brand new. Okay, I was at the trial. I handled all the briefing. This is all brand new. This is
why the reason for the first time up on appeal.
Yeah, this is all raised for the first time up on appeal.
They asked for apportionment. They asked for an instruction. They asked to admit. So you can't say that they didn't raise any of it below.
But they did not brief all of this Banks analysis. They asked for the jury to be able to apportion damages for PDCM to appear in a verdict form. That's an interpretation of a statute. Now, this whole thing about pro tanto share and proportionate share, we're seeing this for the first time on appeal. And if indeed this court is concerned with making sure there's a record fully developed below so that you can have an informed decision, this is not the case. This is not the case for us to be, heading down into this yellow brick road of interpreting statutes and creating a common law, when the reality is there was a black and white third-party complaint that could have been filed, cross-claim that could have been filed, affirmative defenses that could have been pled, discovery answers that specifically did not blame PDCM until 20 days before trial was set. And then unsworn discovery responses were submitted all of a sudden, blaming PDCM. And that is what spurred this entire issue. And in a
other
joint,
words, this is a bad case for whatever they want us to do to change the law.
It's just not it, because there are just so many issues that happen below that there's a reason why, you know, for 47, our statute has been on the books for 47 years. 1451D has been on the books for has this ever come up before this court? No. This is a creature of the litigation strategy that was chosen by Pueblo. And this whole idea that there's double recovery, and it's just not true. And I encourage the court to really focus on our briefing and our history of the case, that we try to some of the for clarification purposes. In my haste to edit, I edited out some references to in our brief. And I just wanted, for housekeeping purposes, if you permit me to, on page 14 of our response brief to Pueblo, the JA references of 11 to 13, 75 to 78, and 73 to 74, I took out the 2. So it should be 211 to 213, 275 to 278, 273 to 274, and then JA 288. And the same error occurred in our amicus response on page 10. There should be a 2 in front of those JA references. My editing got aggressive to the point where it took out the 2 when I wasn't supposed to have taken out the 2.
How about the Third Circuit in Gomes? You know, didn't they? You know, it's not as if this is coming from left field completely. Didn't the Third Circuit sort of address this in Gomes?
The Gomes case was a 1974 case, and Gomes did not really. I don't think they specifically addressed the issue, or we're dealing with the facts we're dealing here with, where there was
I'm saying it because you said that this comes from this yellow brick road that we have never had before. Obviously, it's not a new issue to the courts.
It's that, well, to this court, it is. The Third Circuit may have looked at it briefly in Gomes, I think on a different circumstances. It was in Gomes, there was a refiled action. It was not the original action that they were dealing with. And they were dealing with a different factual set of circumstances. And so in the facts of this case, where there was no third party complaint pled, no affirmative defense, all of their discovery responses, and the prejudice to the plaintiff is severe. I mean, plaintiffs in a joint and several liability jurisdiction, we don't settle because you go and you get your recovery against all or both. It's the way they litigated the case and lulled the plaintiff. Okay, you're not blaming PDCM. We're going to compromise our claims for all different reasons. But the idea that now they're not just trying to get a new trial. They're trying to get a new trial in an attempt to reduce what Ms. Palermo is going to ultimately recover in this case. And that is fundamentally unfair.
Okay, thank you.
Thank you.
Sorry, I see you got 3 minutes. No, 5 minutes. Sorry, 5 minutes.
Thank you, Chief Justice. The plaintiff sued the landlord for negligence. The landlord was a party to the case for 5 years, 5 years of litigation, 5 years of discovery. The idea that suddenly this is a surprise, the landlord's negligence would be an issue at trial, is simply untenable. It was an issue for 5 years in the case. Throughout that 5 years—
Not for you. You didn't raise it as an affirmative defense. You didn't, you never sought to even allege that other parties are responsible. So I don't know that for you that it was an issue.
Well, Chief Justice, facts aren't only pled for one party. A defendant can rely on the facts that appear on the face of the plaintiff's complaint. If you look at all of the decisions, the federal persuasive decisions that have been provided by the plaintiff—
That's the detriment that you take, because when they withdraw those facts and dismiss that defendant, then you're left holding nothing.
Sure, Chief Justice, but the complaint was never amended after the landlord was dismissed. There was no new pleading filed that removed the landlord's negligence. It was always in the operative pleading. The operative pleading going to trial alleged the landlord was negligent. The only thing World Fresh Market was asking to do was offer evidence supporting the plaintiff's own allegations that she did not remove from the operative pleading. So the idea that she could be prejudiced by evidence supporting her own claims would be a difficult one we submit for the court to adopt. The whole idea behind requiring the pleading of an affirmative defense is so that the facts that are going to be tried at trial are known to all the parties. Here, the facts that were going to be relied upon for this defense are all on the face of the complaint. So if you look at persuasive federal authority interpreting Rule 8, you'll see that there are a number of cases provided in the briefing here that where a statute of limitations defense is pled on the face of a plaintiff's complaint, the defendant doesn't waive it by not specifically stating in the affirmative defense statute of limitations. Same with comparative negligence by the plaintiff, where the plaintiff puts facts in her own complaint alleging her own negligence. The defendant is not required then to repeat those allegations. The allegations that are in the pleadings are the allegations for everybody. So there's no requirement here that the pleading be repeated, and there's a good reason for that. Otherwise, you would have World Fresh Market and other defendants basically doubling the amount of pleadings, repeating everything that's been said by the plaintiff in support of their affirmative defenses. So it's 5 years. For 5 years in this case, the plaintiff knew that Section 1451D would require the jury to apportion liability between these two co-defendants. Everybody knew that there was going to be an apportionment made in the case. The only thing that's different now is that one of the tortfeasors was dismissed by pretrial settlement. None of the facts that supported that negligence were removed from the case. All of the discovery had already occurred. 5 years of litigation had occurred under that assumption. And the idea that there's a prejudice from wanting to go to trial based on 5 years of litigation and the facts of the plaintiff's own complaint, the plaintiff has no right to claim prejudice because World Fresh Market didn't affirmatively inform her of the legal theory they'd be pursuing in the case. She had a right to know the facts that were going to be an issue, but she did. She pled them. She pled the landlord's negligence.
Yeah, but you had a right, if you wanted to have the apportionment, to keep that party in as a defendant so that then you could have the apportionment. And this party was dismissed quite a long time, even though you said you didn't get notice. It's clear from the responses, the court orders, that you did have notice of the settlement and of the dismissal. But what it comes right down to is, who can it be apportioned to? And I think the statute is pretty clear that it is amongst defendants, and that you allow that defendant to be removed. I don't see how even the amici don't want the evidence of the settlement introduced in evidence, because they know that that would probably prejudice the entire, so make it clear that somebody was at fault. And the other side is saying that they would never have agreed to dismissal if you want to do that, because they wanted the two of you to go at each other and they just sit back and not have to worry. Anyway, you've got 10 seconds if you want to say, wrap it up.
Chief Justice Hodge, World Fresh Market could not have brought a claim against the landlord. It was not alleging the landlord was negligent or liable to World Fresh Market. It was alleging the landlord was liable to the plaintiff. There is no cross-claim or third-party complaint that would permit World Fresh Market to allege the landlord was negligent to the plaintiff. Thank you.
Thank you. The matter will be submitted. Again, thank you all. And
thank you, Your Honor.
matter is adjourned.
Thank you.